A new 2A threat hiding behind the Fourth Amendment. What if I told you that your rights as a lawful gun owner could be erased in the blink of an eye, not by gun control laws, but by a misused police power? The Supreme Court just handed down a 9-0 unanimous decision in Barnes v. Felix, a case that has nothing to do with firearms on the surface, yet everything to do with your rights, if you ever find yourself on the receiving end of police action. This decision directly challenges how force, especially deadly force, is judged by courts across the country. And if the ruling spreads to related gun cases, like the warrantless home entry challenge in Case v. Montana, we could see a massive expansion of your protections under both the Fourth Amendment and the Second. In today's video, we break it all down. If you believe in standing your ground, knowing your rights, and protecting your home, subscribe Survival Lawline right now, like this video, and let's walk through this ruling together, because this changes everything. Chapter 1. What is Barnes v. Felix? The case of Barnes v. Felix didn't begin in a courtroom. It began on a Texas freeway with a minor traffic stop that turned deadly in just 5 seconds. But what unfolded led to one of the most significant Supreme Court decisions of the year. The case stems from a shooting during a toll violation stop. A police officer fatally shot a man named Ashton Barnes. The Barnes family sued, claiming excessive force was used. Lower courts sided with the officer, citing the moment of threat rule. The Supreme Court saw things very differently. This case may look like a traffic stop gone wrong, but in reality, it redefines how courts must analyze deadly encounters between police and citizens. Chapter 2. The fatal encounter that changed everything. The facts are quick but powerful. Officer Felix pulled Barnes over for unpaid tolls. What happened next was tragic and legally groundbreaking. Barnes opened his car door, then suddenly tried to flee. Officer Felix jumped onto the moving car's ledge. Within seconds, he fired 2 shots, killing Barnes. The officer claimed self-defense during a moment of danger. Lower courts agreed, using a limited snapshot of the event. But the Supreme Court asked a deeper question. Shouldn't we consider the whole picture, not just the split second of danger? Chapter 3. The Fifth Circuit's dangerous rule. Before the Supreme Court stepped in, the Fifth Circuit Court relied on the moment of threat rule, a doctrine that narrowed the lens of justice too tightly. This rule judged only the instant when the officer felt threatened. It ignored all events leading up to the shooting. Courts weren't allowed to consider whether the officer created the danger. It prioritized officer safety over full constitutional analysis. The rule made it nearly impossible to hold law enforcement accountable. By focusing only on the final seconds, this doctrine failed to protect citizens from excessive and unjustified force, even in cases involving lawful gun owners. Chapter 4. The Supreme Court's 9-0 wake-up call. In a rare moment of unity, all 9 justices rejected the moment of threat rule. Instead, they emphasized the totality of the circumstances. Justice Sotomayor delivered the unanimous opinion. The court ruled that force must be evaluated in full context. Courts must analyze every detail, before, during, and after. Prior conduct by the officer can now be considered. A broader standard means more protection for your rights. This decision doesn't just affect one man's tragic death. It resets the national standard for judging police use of force, especially when it involves armed citizens. Chapter 5. Why this impacts gun owners directly. Even though this case didn't involve a gun owner, the implications are massive for the 2A community. Why? Because gun owners are disproportionately affected by police use of force decisions. Lawful gun owners are often misjudged in police encounters. The ruling now allows courts to evaluate whether officers escalated the situation. It helps prevent trigger-happy responses during lawful self-defense. It may affect future rulings on no-knock raids or red flag seizures. The new standard puts your Fourth Amendment rights front and center. If you've ever worried about defending yourself or your home, this ruling gives courts a better tool to determine whether law enforcement crossed the line. Chapter 6. Back to court with new power. After the Supreme Court decision, Barnes v. Felix was immediately sent back to the lower court for a full reevaluation. But this time, the game has changed. The case will now consider everything that led to the shooting. Ashton Barnes's father is representing the family pro se from prison. He has already filed to restart the trial under the new precedent. The lower court must now apply the totality of circumstances test. The door is open for accountability where there once was none. This is no longer about justifying split-second decisions. It's about uncovering the truth every step of the way and protecting rights that were once ignored. Chapter 7. What this means for future cases. The ripple effects of this ruling could be enormous. Every pending or future case involving alleged excessive force must now meet this new Supreme Court standard. Courts can no longer ignore how officers created or escalated danger. Lawsuits by victims of excessive force now have stronger standing. Even federal agents may fall under the same scrutiny. The case sets a new bar for traffic stops, home entries, and raids. It will likely affect future challenges involving red flag laws. Every time a law-abiding gun owner is confronted by force, courts must now ask more than just, was the officer scared? They must ask, was it reasonable? Chapter 8. The link to warrantless home entry cases. This ruling is already influencing other major cases. The most notable is Case v. Montana, which involves warrantless home entry and firearm confiscation. That case deals directly with police entering homes without court orders. Oral arguments have already taken place at the Supreme Court. The Barnes ruling was cited in both legal briefs and discussions. Judges must now weigh the full context of officer conduct. This may strengthen defenses against illegal gun seizures. If Case v. Montana adopts the same totality standard, warrantless entry could be much harder to justify. That's a game changer for everyone defending their home. Chapter 9. Why this is a Second Amendment issue too. At first glance, this seems like just a Fourth Amendment case. But the way courts evaluate police encounters could now directly affect your Second Amendment protections. Firearm owners often face scrutiny and suspicion in police stops. This ruling gives judges flexibility to rule in favor of innocent citizens. It may curb abuse of power in future gun-related prosecutions. Courts must look at why an officer acted, not just how. That shift benefits lawful gun carriers during tense encounters. If you're carrying legally and a cop acts recklessly, your actions and theirs must now be reviewed as a whole, not in a vacuum. That is a massive constitutional win. Chapter 10. A new era of legal self-defense protections. This ruling might be the beginning of a new wave of pro-liberty jurisprudence. The totality test doesn't just protect you in court, it deters abuse before it happens. Officers may now think twice before escalating a lawful stop. Courts will examine intent, context, and proportionality. Lawyers for gun owners will have stronger cases to defend with. The ruling limits blanket immunity in use of force claims. It restores the principle that government power must serve justice, not override it. Your right to bear arms now comes with greater legal armor. The state cannot shortcut responsibility just by claiming fear. That fear must be proven, examined, and justified. This 9-0 ruling is just the beginning. The Supreme Court just made history with this 9-0 ruling. But the real fight is just beginning. As Barnes v. Felix returns to the lower courts and Case v. Montana waits for a decision, we are standing at a turning point for both the Fourth and Second Amendments. This isn't just about one man in Texas. It's about every law-abiding citizen who carries responsibly, who values liberty, and who wants justice to apply fairly, not selectively. So now we ask you, how do you feel knowing the courts will finally be forced to see the full picture? Drop a comment below and let us know where you stand. Subscribe to Survival Lawline right now. We break every ruling, every update, and every legal battle down into what it means for you. Hit the bell icon, share this video, and help us spread awareness, because informed citizens are the last line of defense. Thank you for watching, and remember, this nation was built by armed scholars, and it will be defended by informed Americans like you.